Thank you so much. It's fun for me because as I deepen my involvement with NACRA and with Leading Age as well, I get to know more and more people, and that helps me be incentivized to know more and more about the law connected to continuing care. I spent part of my summer this year doing a tour of some CCRCs, but more importantly, I ended up spending 2 important days at the knee of Jack Cumming in La Jolla, California, and really deepening my awareness and my concern about financial obligations of CCRCs and the ways in which trouble can occur. For those of you who know me, you know that my original involvement with CCRCs was as a result of a group of residents coming to what I was operating then as an elder law clinic, an elder protection clinic. They generated my interest in CCRCs. I knew nothing about them before that moment, other than the fact that I lived in central Pennsylvania, and there's a large number of continuing care communities in Pennsylvania. And so over time, I sometimes say CCRCs are my hobby in elder law, but it's become a hobby that's become pretty big in my life because it now has generated, I used to teach all trial skills courses at the law school, so I taught evidence and trial advocacy and those types of courses. Now I teach contracts, not-for-profit organizations law, and so you can see how my study of these institutions has actually affected my teaching package. I'm going to talk today a little bit about a case that I think holds some potential for us to think about the relationship between residents and provider organizations, and more importantly, provider officers and directors that may be useful to us in the future. The case is a disturbing case. It's called Leamington Home for the Aged. Leamington Home for the Aged was a classic nursing home that started in 1880 as a home for colored women, as they were referred to in those days. And it was successful in its own way for many years. And 100 years later, in 1980, it began to realize that it was no longer financially viable in the format that it was, so it made a major decision to modernize and to expand. And so they went from a fairly small facility to a much larger facility, and over the course of the 100 years, they'd also expanded their scope of operations for older persons in general, although they always served a large community of African Americans in the Pittsburgh area. They ran into some problems as a result of going from a relatively small organization to a relatively large facility. They bought a big new took over a big new residential facility. And particularly they got themselves in trouble with Medicaid reimbursement rates and the way in which that works for nursing homes. And in a sense, if you went back into their finances, that's where everything went wrong. However, they hung in there in operations in large part because of very generous donors, very committed board of directors to the cause of serving needy African Americans in Pittsburgh as they became older. However, things still didn't go very well, and finally, in 2005, the officers and directors filed for Chapter 11 bankruptcy in the federal courts in Pennsylvania. During the petition reorganization, it became apparent that they could not continue to operate for a variety of reasons, and so the decision was made to liquidate and to transfer residents away. Now remember, this was a nursing home, this was not a continuing care facility. Where I began to get very interested in the case was a group of unsecured creditors of the nursing home filed what's called an adversary proceeding in bankruptcy against the officers and directors of the Leamington home, saying, wait a minute, not so fast. You may be able to liquidate as an organization, but you officers and directors have breached your fiduciary duty to us as creditors, and you have also committed fraud by what's called deepening your insolvency, and thereby not making it possible for original creditors and new creditors to have any chance of being paid. Yes, I see a hand.
Could you put that maybe about 2 inches closer?
I will do that. How's this? Is that better?
That's wonderful.
Okay, very good. So, I'll review the basic concept because everything starts from here. So, a group of unsecured creditors filed what's called an adversary proceeding in bankruptcy, in essence, a separate lawsuit against the officers and directors of the Leamington home with two different allegations: breach of fiduciary duty to the creditors and a concept that's related to fraud known as deepening insolvency. When they filed the suit, I didn't even know they filed the suit, actually. I didn't hear about it until the federal court actually dismissed the lawsuit, and I thought that was the end of the suit. However, it went up on appeal to the Third Circuit, and lo and behold, the Third Circuit said, and they reviewed the whole history of the organization, we agree that a factual case has been alleged that will permit this case to go forward for trial against the officers and directors for personal liability for these claims of financial mismanagement of the nursing home. Now, the allegations in this case were very, very serious. So when the case came back to trial, the allegations included a history of the CEO really only working part-time, often not being there for days at a time. The board of directors, often members of the board of directors did not appear at annual meetings. There was times when they didn't keep minutes of their annual meetings. They had a financial committee that would meet but not keep minutes of what they were talking about. They were borrowing more and more money. There was an in-house foundation that was funded from people who were donating to preserve the nursing home, but the money went into a nonprofit foundation. The nursing home itself was nonprofit, but the money was held in a foundation, and there was an odd relationship between the two, and many of the officers were officers and directors of both the nursing home and the foundation. But the key thing was that this case was going to go to trial on these two concepts. And the law, as I've now understood the law, does support this. Traditionally, fiduciary duties run from, in a corporate setting, run from the officers and directors to the corporation. So whenever residents have come to talk to me about why doesn't my CCRC have a fiduciary duty to me as a resident, I say because there's this tension. The officers and directors have a statutory duty of fiduciary duty to the corporation itself. Now, most of the time that lines up completely, right, with the interests of the residents. And in an ideal world, that's true. But not always, right? Particularly if it's a corporation that's intent on expansion and is trying to build new facilities and has a parent and child relationship in a corporate structure, the fiduciary duties to, quote, the corporation become much more complicated and thus diluting the potential for it to match up perfectly with the sense of protecting the residents. Okay, so we have fiduciary duties that run from officers and directors to the corporation itself. A second complication to this lawsuit was what we call the business judgment business judgment rule. This rule exists for both for-profit and non-profit corporations. It always sounds good the first time you read the business judgment rule, and I'll read it to you. An officer shall perform his duties in good faith, in a manner reasonably believed to be in the best interests of the corporation, and with such care, including duties of responsible inquiry, skill, and diligence, as a person of ordinary prudence would exercise under similar circumstances. It sounds like it's a duty for which a breach should give rise to a cause of action. As a practical matter, the business judgment rule insulates officers and liabilities from anything other than true gross negligence. So it's not an ordinary negligence standard as a duty to create a breach. It's a higher standard. So that's why in the Leamington Homes case, it was rather easy to make a breach of fiduciary duty case because the officers and directors had abandoned any duty. They weren't exercising business judgment. They were not paying attention to the books and the records. They were hopeful that their little nonprofit operation would survive rather than doing a businessman's duty, a businesswoman's duty of trying to make sure that it did survive. And if that was the only part of the case, that might not be terribly interesting for us. But here's where I began to realize the potential for CCRCs. The court made a point of saying, fiduciary duties are owed not only to corporations and its shareholders, but also to the creditors of the insolvent operation. So there is this notion in bankruptcy law and corporate law that when an operation becomes technically insolvent, meaning more liabilities than assets, a simple definition, the expanded duty of care now goes to the creditors themselves. So that, in a sense, they become almost one with the corporate entity. Well, guess who I was looking at as creditors? Unsecured creditors in most cases, just like in Leamington Homes, residents of CCRCs. So that now gives us an opportunity to argue directly that breach of fiduciary duty, that the fiduciary duty is owed to the creditors of the nonprofit, including residents, and particularly once they go into bankruptcy, but I would argue even when they are, quote, technically insolvent. In the deepening insolvency concept, which is a separate concept, it's more of a controversial issue, but in many ways it lines up so well with what I see happening in the occasionally badly run or, just unfortunate timing CCRCs. Deepening the insolvency is defined as an injury to a debtor's corporate property from the fraudulent expansion of corporate debt and prolongation of corporate life. So the fraudulent expansion of corporate debt. To prove a case of deepening insolvency, the director's actions must cause the deepening debt. The bad news is you do have to prove fraud, and fraud always is a heightened burden of proof in the law. You have to usually prove, there's some exceptions, but you usually have to prove intent to deceive, and thus a claim of negligence alone usually will not suffice. But in this case, in the Leamington Home case, what was happening is they were borrowing more money, perhaps if it had been a CCRC, having more people pay entrance fees into their CCRC after they're insolvent, but before the bankruptcy is actually declared. And thus they are jeopardizing the corporate property as a pool with which to pay claims. The reason why it was important in Leamington Homes is because what happened was there was nobody willing to take over Leamington Homes by the time they actually made it into the bankruptcy court. Earlier, there were suitors. There were operations willing to come in and say, we can run this, this nursing home if we catch it in time, and yes, some debts will have to be wiped out in the bankruptcy process. We won't assume all previous debts. But by the time they got so deeply in debt, there were no viable operators to turn over the operations to. That's what I always worry about with CCRCs. Right now, we're still in a marketplace where there are good suitors for most CCRC operations that can come in and rescue a, quote, failing operation. Well, this case was actually permitted to go forward to trial when it was remanded from the Third Circuit. The case was tried in March of 2013. There was a jury. The jury awarded a total of $5.75 million against 15 of the 17 defendants personally, including $2.25 million that was direct liability for deepening insolvency, plus punitive damages against 2 former officers and 5 of the 13 former directors. The key here was that officers and directors were found to have enabled the corporation to continue to accrue debts after insolvency. And that was viewed as the hallmark of this concept of breach of fiduciary duty in the context of debtors. Now, what does this translate to those of us who hope our CCRCs never go into bankruptcy? Certainly it creates a potential viable cause of action for personal liability against corporate owners of nonprofit CCRCs that go into bankruptcy. Piercing the corporate veil would be one way to try to use these concepts, and I've seen it done in Florida and some other states. But I think it's more important to us to think about how do we use it as a proactive measure. I think that the way in which this becomes important is that residents are an important way of gaining information, working with existing officers and directors, and collecting the information that suggests whether they're getting into an inappropriate deepening insolvency situation. So what I would do is I would recommend that resident councils begin to have documented practices of preserving all marketing materials used with residents, because those change all the time, and those are part of what attracts the new creditor, and the creditors being new residents. And what you need to do is know what's being said to them. Are they being told the truth about any financial insolvency, even if it's not bankruptcy? So I would want all marketing materials to be preserved by residents, organizations, and kept in a way so that you know what the date that they were used. And if you can even tie the date that they were used to actual residents, that's even better. So just have an ordinary friendly practice of new residents. Can we see what marketing materials were presented to you? Would you mind if we kept a copy of them for our records with your name and date as to when they were used? Marketing materials are often very important to any claim by consumers that they have been mistreated under Consumer Fair Trade Practices Acts. And that's a separate cause of action from the corporate causes I just mentioned. Second, of course, I would want copies of all contracts, again with resident names, and because again the contracts change from year to year, sometimes from client to client, so that you know in addition how those contract terms are being expressed as to whether or not there's any potential for deepening insolvency. And then finally, as notices come through the stream talking about changes in billing, changes in what you're going to get for your bills, services, I'd want to keep copies of those as well and keep them by date so that you have this set of preserved materials that in the event, and hopefully the unlikely event, hopefully the never occurring event of a insolvency turning into bankruptcy, you have a way to make sure that any claim against the parent organization, particularly in order to recover what I think are the most critical unsecured debt, are upfront fees, whether they're, upfront fees, whether they're refundable, partially refundable, or non-refundable, are the core of the unsecured creditor's claim. And certainly if they're refundable in any form, that would be the type of unsecured debt that would become a key question in the bankruptcy. But even if they're not refundable, if it's a life care contract where you're not going to get a refund, I would want to keep it. I would want to know what the changes in those attractions, those advertisements in the contracts were. Ultimately, what you're going to be able to do then is when you talk to, if you have to have tough conversations with management of the CCRCs at some point, you can say, look, we understand the concept of fiduciary duty, not just from the corporation, from the officers and directors to the corporation, but also to us as creditors of the corporation. And we want to know, we have a right to know as creditors, what the actual finances are. And by being an informed consumer during the life of your residency, I think that's more likely that the players on the other side of the table are exercising their professional due diligence.